Hi, good afternoon. This is Carla, and I am here. I'm waiting for the attorney Lisbeth Mateo to answer questions, immigration questions in regards to public charge and etc. So right now I am waiting for immigration attorney Lisbeth Mateo to sign in and to answer questions about unemployment for DACA recipients and TPS recipients and etc. So we're just gonna wait for a few minutes for her to sign in, and she's right there. Yes, probably in line soon. We're just waiting for her to join. So just bear with me a couple seconds. Hey. Hi, can you hear me well?
Yes, I can hear you. How about you? Can you hear me?
I can hear you well. So anyone in the audience, can you hear both of us well? I think so. Can you guys hear us? I'm just going to take that as a yes.
Yes.
Yeah. So how are you, Lisbeth?
I'm good. I'm, just busy trying to get as much work done, trying to stay away from as many people as possible, keeping my distance to prevent the spread of this virus. I think we're all trying to do our best, and it's difficult not to be able to do all the things that we're used to, but, taking it one day at a time.
Awesome. Yes, me too. I'm just here trying to do the best of this quarantine, keeping busy, exercising, cuddling with my cat, all good stuff.
Yeah. I need to exercise a little more, but I'm definitely keeping busy.
Awesome. Yes. So without further ado, for those of you that work and are in lunch or whatever, I'm going to just give the ball to Lisbeth. She is the expert here. For those of you that don't know who she is an immigration attorney here in the Los Angeles area, and she's amazing. She's an immigrant herself, and she's been on the streets and off the streets, and in the legal field. So if there's anyone that we should trust, it's definitely her. So so my hats, and she's amazing. So Lisbeth, please take the ball.
Thank you so much, Carla. Just a little bit about myself for those of you who don't know me. My name is Lisbeth Mateo. I'm originally from Oaxaca, Mexico, and I am an immigration attorney based out of Los Angeles. My office is in Wilmington, but I also happen to be undocumented. So I'm not a DACA recipient. I'm undocumented. I don't have any kind of legal protection against deportation, but I am very blessed. I'm very privileged in many ways to be able to do the work that I do, to be able to represent people in immigration proceedings and removal proceedings, to go to court, to go to detention centers, and just doing the best I can with what I've been able to have access to, and to have the trusted people like Carla and many of you who have reached out for legal advice in the past. And if you do reach out for your questions, I'm happy to answer them. But I wanted to, besides introducing myself, take the time to answer some of the questions, some of the most common questions that we're hearing from people. I know that I received many calls from my clients, many messages from people on social media asking about receiving unemployment benefits and how this is going to affect their case, how this is going to affect them if they are deemed a public charge. And so I'm going to answer those questions, but I want to start with addressing what the public charge rule is, just in case some people don't know or some people forgot. And then I'll talk about what are the benefits that will be considered under the public charge rule, and whether receiving unemployment benefits will affect you if you are an undocumented immigrant trying to get a green card, or you're applying to become a citizen, and then also who can actually access unemployment benefits if you are undocumented. Not everyone can access them, so we'll talk about that. But I'll start with what's the public charge rule. And so the public charge rule is a grant of inadmissibility, and that is just to say that essentially there are grants of inadmissibility in immigration, and those are reasons for which an immigration officer can deny someone a green card or a visa or admission into the United States. The public charge rule has been around for a long time, but it was recently updated. So there's a new version of this rule, and this is why we're talking about it today, because there's a lot of questions about the new public charge rule that went into effect in February 24th to be exact. But it doesn't apply to everyone. It doesn't apply to every immigrant. It doesn't apply to certain undocumented immigrants seeking certain benefits. It only applies to people who are seeking to adjust status through a family member. For instance, if you are the child of an undocumented parent and you want to adjust, you want to petition your parent, the public charge rule will apply to them. If you are the spouse of a U.S. citizen and that U.S. citizen wants to petition you, the public charge rule will apply to you. If you already apply, your case is pending, this new rule is not going to apply to you if you apply before February 24th, 2020. So it also applies to people who are seeking a visa or seeking admission into the United States. It does not apply, however, to those individuals who are seeking a U visa, who are applying for a U visa or a T visa, or are asylum seekers, have a pending application for asylum. Even if they are now seeking a green card, they are applying for a green card based on U visa status because someone was a victim of a qualifying crime, has a U visa currently, and is now applying for a green card. Even though they're applying for a green card through a U visa application or U visa status, T visa, victims of human trafficking, or were granted asylum and now are eligible to get a green card, that public charge rule does not apply to them. Okay, so it's very important that if you have a pending case or want to apply for any immigration benefit, that you consult an attorney so they can actually review your case and tell you whether the public charge rule applies or doesn't apply to you. Now, what are some of the benefits, the public benefits that are taken into consideration to determine whether someone is a public will be deemed a public charge? So again, this public charge rule has been around for a long time, for many, many years, but it was recently updated to add additional benefits. So any health, housing, or nutrition programs that are federally funded will be considered for a determination of whether you can be deemed a public charge. Things like Medicaid, federally funded Medicaid, so medical benefits, unless you are someone under 21 or you're a woman who's pregnant now, or who gave birth 60 days, less than 60 days prior to, less than 60 days ago, or during an emergency. If this is an emergency situation, any medical benefits that you receive will not count against you, essentially. SNAP benefits or food stamps, formerly known as food stamps, Section 8 housing benefits will also be counted. Any use of cash aid, including the temporary assistance for needy families or SSI, would also be counted against you if you are using them. It does not include, however, the CHIP program, any state, local, or tribal healthcare benefits. And so if you can access healthcare benefits, especially during this time, that are not federally funded, okay, the money doesn't come from the federal government, you're okay. It's not going to count against you as a factor for determination of whether you're public charge or not. However, one very important thing to take into account is that receiving public benefits is only one factor that the government has to take into account to determine whether you're a public charge. There are many other factors that they have to take into account. So just because you have received Medi-Cal doesn't mean that you're now going to be considered a public charge. Not at all. The government has to take many other factors into account. Your education, your age, your health, whether you have if you have a work permit and you've been working and paying taxes, that's great. If you have good credit, that also counts in your favor. As long as you don't have a lot of debt, as long as you're not primarily dependent on this benefits, you should be fine. But again, for any immigration case, it is very, very important that you consult an attorney to review your case really well and to make that determination on whether you will be considered a public charge or not. One thing that is very important is that a lot of immigrants in general are not eligible for certain federally funded benefits. Okay, so we're already not eligible for them. If you have a family member who receives those benefits, it's not going to count against you. But the government will essentially have to look at several factors in your case to determine whether you're a public charge or whether you would be deemed a public charge in the future. Also, just because you receive certain benefits for a month or two, or you're thinking of getting some of these benefits if you're eligible for the next couple of months while we see what happens with this pandemic, is not going to be enough to deem you a public charge. If you are thinking of seeking adjustment of status right now, again, consult an attorney. That's the best thing you can do. But USCIS has issued new guidelines in response to COVID-19, in response to this pandemic. The government understands, and we all understand, that it is very, very important for all of us to do our part in preventing the spread of this virus, and seeking medical treatment, preventive treatment, testing, screening is not going to count against you as a public charge benefit, or as a benefit that can be counted as public charge. So USCIS has made it very, very clear that if you seek testing, if you seek any kind of screening or treatment for COVID-19, it is not going to count against you in the public charge determination in any immigration case. So everyone is encouraged to seek medical treatment if you think you have the symptoms, if you've been exposed to the virus. It is very, very important that you do that. I know it's very scary, but it is not going to count against you. If you are someone who is thinking of applying for a green card in the future, in the near future, and you seek medical treatment for COVID-19, or you seek certain public benefits, USCIS has also made it very clear that if you are currently not working because you've been laid off, or because there are restrictions as to the kind of work that you can do, or the hours that you can work now, or if you're a student and you're not in school right now because school is closed, if you are going to apply for any immigration benefit, you can always include a statement. You can always explain why you access certain public benefits during this pandemic, why you're not working currently, and maybe your income is not the same that it was a month ago, or your income this year is not going to be the same as last year, or why you're not in school if you are someone who is required to be in school in order to keep certain immigration benefits. You're going to be able to explain all of that, and USCIS is going to take that into consideration. So don't be afraid to especially seek medical treatment if you feel like you're sick, if you feel like you've been exposed to the virus, or if you have symptoms that are consistent with the virus. It is very important that you seek treatment. Your health should be above anything else. So that's those are the that's what I can say about public charge and COVID-19. Before I talk about unemployment, Carla, I don't know if you have any other additional questions regarding public charge specifically.
Mm-hmm. So, hey, it's Paris. Ask, does my care program with Edison be considered a public charge?
A little bit. So, any medical programs that are not funded by the federal government, so if it is not federally funded, it is not considered a public charge.
Mm-hmm.
So yeah.
So, Ramirez Adri 15 asks, does medical apply? Not emergency, but full-on medical.
So Medi-Cal, full non-emergency Medi-Cal will be is something that if you're over 21 will be considered a public benefit for public charge purposes. But if you have Medicaid now and you're seeking treatment because of COVID-19, it is not going to count against you. Okay. You can always explain why you're seeking this benefit.
Okay. So this is another question, and I'm gonna quote, I know testing for COVID-19 is not considered a public charge. However, I'm wondering for folks who are undocumented and already living in the United States wanting to apply for CalFresh or the listed benefits counting against immigrants, will have to undergo test, or is it only for folks returning back the United States? Okay, this is just actually not that clear, but I think what she's asking is that she's aware that a lot of treatment against COVID, it's not deemed a public charge right now. But she's asking for those that are completely undocumented, that have no benefits. And if they have to get other benefits due to the charge, due to what's happening, the pandemic, such as CalFresh and etc., would that be count against them?
So if someone is completely undocumented and needs medical treatment or needs other public benefits and they're eligible to seek those benefits, what USCIS has said is that during this pandemic, if they seek certain benefits, certain public benefits, and then they, next year or in a few months decide to apply for a green card, they can explain why they had to seek those benefits. They can explain what they lost their job and they were not able to pay for medical treatment, or they needed assistance with food or rent or whatever else they're trying to access in terms of benefits. You can always explain. Now, it is very important for people to understand that just because you seek benefits during a short period of time, it's not going to be, that doesn't automatically make you a public charge. Mm-hmm. You can explain the reasons why you're seeking these benefits. And then USCIS will also consider many other things. They will consider your age, they will consider your education, they will consider whether you're employed at the time, whether you've been paying taxes, if you have a work permit, whether you have good credit, if you have any debt. There are many factors that USCIS will consider to determine if you're a public charge. So just the usage of one or two public benefits, it's not, it will not automatically make you a public charge.
And this question is from Edwin. What if our parents received governmental assistance while we grew up and we were benefiting from those benefits as children?
That's a very good question. Very good question. Thank you so much for asking that. Now, any benefits that your parents or you received prior to February 24, 2020 do not count. Okay? So if you're someone who is applying, wants to apply for a green card, you're eligible now, you want to apply for a green card in 6 months from now, and you were a child when your family received certain benefits, that doesn't count. Or you received public benefits last year. As long as it was before February 24th, 2020, you'll be fine. That doesn't count against you. It is starting February 24th, 2020 and on that USCIS will look at what benefits you have received and for how long. And again, it is only one of several factors that they will look into.
This is from Paris Patricia. What if we have full medical or Medi-Cal? I apologize. What if we have full Medi-Cal? Should I cancel it now or wait until this passes? I think, like in California at least, DACA recipients are entitled to full Medi-Cal. There is a lot of like debate in some groups whether that is a good thing or a bad thing. Will that be a public charge or not? It's kind of muddy, like just considering the position that DACA recipients are in currently. So what would that look like potentially?
Yeah, I mean, it's there's no clear answer to any of the questions, unfortunately, because we're dealing with immigration, and immigration is such a ever-changing mess right now. And I think what I would say is this. If you need the benefits, okay, if you are someone who has any health conditions, and you need those benefits, you really have to think about your health first. One important thing that immigration has said during this time is that they will not count certain benefits that are received during this pandemic for the purposes of treating any conditions, for purposes of treating COVID-19, essentially. Now, if you are someone who has medical conditions that could make you more susceptible to the virus, who could, someone who has higher risk factors, I would say it's a decision that you have to make. But in my opinion, your health should always come first. You can always try to explain to USCIS why you have received these benefits. Now, something very, very important. If you are thinking of applying for a green card in 6 months or anytime soon, yeah, they'll look, basically what they have to look at is the benefits that you have received for a certain period of time. And if it is a prolonged period of time, I believe I will have to look into this, but I think they're going to look at the last 36 months prior to when you apply for a green card or a visa. And they will look into whether for 12 months of those 36 months, you have received public benefits. So if you only receive Medi-Cal for the past 2 months, that should not count against you. And again, it is only one factor of many that they will take into account. I think the best answer I have for you right now is you have to consult an attorney that can really review your particular case, because I don't know what your situation is. I don't know what your immigration history is, and I can't really answer that question the way that I wish I could.
This is from Luz Hernandez. For public charge, if the person petitioning, the parents, received or has received Medi-Cal in the past before the age of 21, will that be considered a public charge? I think just correct me if I'm wrong, Lisbeth, but I don't public charges only for the beneficiary, not the petitioner.
Right. So public charge does not apply to U.S. citizens. So U.S. citizens are still eligible to get the benefits that they need. If they qualify for those benefits, of course, there are certain requirements. So if you're a U.S. citizen and you need certain benefits, and if you meet the requirements, then you should be able to get those. And it doesn't affect your parent under the public charge rule, because the public charge rule only applies for people who are seeking entry into the United States, who are seeking a visa, or who are seeking a green card. Okay. So if you're a U.S. citizen, you should not worry about the public charge rule, because it doesn't apply to you. Another important thing, if you receive, whether you're a U.S. citizen or you're an undocumented person, and you receive Medi-Cal benefits before the age of 21, that doesn't count.
Okay, so I think we might have answered all the in regards to the public charge. Like, do you think we're ready to move on to unemployment?
Sure. The one last thing I wanted to say about Medi-Cal though is that if you have emergency Medi-Cal, that doesn't affect you. That doesn't count towards the public charge rule. So if you have emergency Medi-Cal, you're fine.
Okay, awesome. Okay, so I guess like after this, we are going to talk about the unemployment. I see a lot of people asking questions on that too on all platforms. I'm sorry if I look like this all the time, but I'm like looking at both things. Like mainly like the main question that everybody's asking right now is whether they can apply for unemployment if they have a valid work permit, such as DACA recipients, and what does that mean for future adjustment of status? If it applies, and most importantly, well, at least for me, it's if undocumented people without the benefit of a work permit can also benefit from any type of help that the government is providing at this
point. Okay, so let's break this down. Let's start with who qualifies for unemployment benefits. So essentially, people who qualify for unemployment benefits are immigrants, or immigrants who qualify for unemployment benefits are those who have been admitted for permanent residency status. So green card holders can apply for unemployment benefits. Immigrants who are in the U.S. with lawful employment authorization. So DACA recipients are some of those individuals that will be eligible for unemployment benefits. Also, there's other groups of people like refugees, people who have been granted asylum, victims of domestic violence who are the spouse or the child of a U.S. citizen or lawful permanent resident could also seek unemployment benefits. So essentially, those individuals who don't have a green card or who don't have employment authorization at the time or at this time cannot seek unemployment benefits. Every state is different. Every state has different rules. So I strongly suggest that you look at the rules in your state. But in California, those who do have a work permit and have been working and had a work permit during the time that all this time that they've been working, they can seek unemployment benefits. So I hope that answers that question. I know that there's more, but that's the gist of the answer. But again, every state is different, so they have different requirements. I suggest that you look at your state rules to determine whether you're eligible for an unemployment benefit if you have a work permit or you're a green card holder.
Yeah. Let me see if there's anything in regards specifically to unemployment right now in the comments.
I think the other question you asked, sorry, the second part of your question was, what does it mean or what would it mean for me if I seek unemployment benefits if I were to adjust my status in the future? So unemployment benefits should not, I have to be honest, I'm not very clear because I don't do employment law. So I'm not very clear about whether it will, state-funded unemployment benefits should not count against you, okay? Especially because this is happening during this pandemic. There are a lot of people who are losing their jobs. There are a lot of people who have their jobs, their hours have been reduced. So essentially, what I would say is this: if you need those benefits, there is no reason why you should not seek those benefits. USCIS again has said that if you in the future want to apply for a green card, for instance, or a visa, you can explain why you had access to certain benefits during this period of time. If it is related to COVID-19, then you should be able to explain that. But every case is different, and I will suggest that you, before you start any kind of immigration petition, you always talk to an immigration attorney that can review your immigration case, they can review your immigration history, your criminal history, and determine if you're eligible or determine whether there may be some issues. But if you need certain benefits, they're available to you, and you should be able to apply.
So this question is from KDOT. Can undocumented folk receive any type of unemployment benefits despite not having a work permit but having a social security number?
So the answer is, I think the answer to that question is no, because essentially the test, the definition of for someone who can receive public benefits is that the person or the employee has to be available to work. Okay, and available to work means someone who actually has permission to work in the United States. So the government has determined in California, the Employment Development Department, the EDD has determined that undocumented workers are not available to work, which is kind of silly because we're very hard workers, but basically you have to be able to work and be available to work. But undocumented workers who do not have a work authorization are not available to work, so therefore are not eligible for unemployment benefits.
Okay, let me see if there's more around here. Yeah, I think those are we answer all of them. I mean, I have a lot of questions about unemployment, but it's practically the same thing. So yeah. So another thing, another set of questions that I'm seeing, like a trend here, and this is actually very new. So just a heads up to everybody that's watching. The stimulus packet that was unanimously passed by the Senate, it still has to be voted by the House. So that's not a for sure thing, although it is projected that it will pass. And actually, Elizabeth and I just got our hands on the most recent bill, which, by the way, if you want to read it, I can provide it to you. But we just got hands on that bill literally maybe 45 minutes ago. So so that's very new. It just passed last night, and it still has to be voted on. Who knows if they're going to change it? So just a heads up that everything that we talk about in regards to that packet, it's up in the air because we need to review it like line to line, and then also opinions of other experts. What does that mean? And who knows if it changes? So just a heads up. But yeah, it's in regards to that, and mostly, obviously, they're asking about whether DACA recipients or people with Social Security number or people with an ITIN number are eligible to obtain those benefits from the stimulus packet. What I've read personally is that in the beginning of those talks, the Trump administration actually wanted to give that $1,000 or so only to United States citizens, not even legal permanent residents. But due to public outcry, that changed. So now it's everyone that has a Social Security number. I'm not completely sure if it's people that have a Social Security number and a work permit. I'm not sure how they would actually have the time to research that. But what I've read so far, it's people that have a valid and current and working Social Security number in regards to the stimulus packet. Again, it hasn't passed yet in its entirety, and we still need to research it. But what I've read and my understanding is that everyone, that means DACA recipients, people with a work permit, might be able to obtain those benefits. Unfortunately, like the language does indicate that the rest of our community members, the 11 million community members that don't have a social security number, are unfortunately excluded, even if they do pay taxes and file and work under an